Hi, my name is Stuart Koop, and I'm a lawyer at South Coast Law Group in Surrey, British Columbia. In addition to estate litigation and personal injury law, the lawyers here provide legal advice in family law matters, which include such issues as divorce and division of assets, support, custody. Our clients usually contact us when they have questions concerning their rights and obligations that flow from the breakdown of their relationship or marriage. Your rights and obligations will, of course, depend upon your unique circumstances. They may include the age of the children, how long you've been together in your relationship, the nature and value of your assets that need to be divided. In any event, once you have received that initial advice on your rights and obligations, you're probably looking for resolution to the issues. You have two basic options. You can either resolve your issues by way of separation agreement, or you can proceed with litigation to get a court order. So if the two of you, if you and your spouse are agreed upon how you want things resolved, you've figured out where the children are going to be, how you're going to split up your assets, you can enter into a separation agreement. Now, this option is certainly the quickest and cheapest way of resolving your issues. The downside is that you may not have, well, there's no guaranteed resolution. If negotiations break down, you might be left with nothing. The three conditions to a separation agreement are that it must be fair, it has to abide by the family law principles of British Columbia. The second, you have to agree. You can't be coerced or forced into signing the document. And thirdly, you should receive independent legal advice so that both parties understand what kind of document they're signing. If you can't agree by a separation agreement, or if you can't resolve by way of separation agreement, rather, you may be forced to deal with the court process and litigation. That would start by filing documents in court. Your spouse would then be obligated to respond, and ultimately a trial date may be set where a judge will determine what's to come. This option is generally takes longer. It's certainly more expensive, but you will have a guaranteed outcome and you won't be forced to wait indefinitely. It's important to note that if you do begin the litigation process, you can stop at any time if you and your spouse change your mind and you happen to agree, and then you can resolve your options or resolve your issues by way of agreement or consent order. So if you have any questions about these issues, feel free to contact us for a free initial consultation at 604-496-5096. Thanks.